Thank you to everyone for joining us today. This is the Mission Impossible series on employment law and COVID. So fantastic to have everyone joining us today. As a quick reminder, again, if you have not typed in your name and organization in chat, please go ahead and do that. We'd love to know who we're hanging out with today. And let's kick things off. So I'm Paul Strahl. I am with GoTriangle. And let's make sure my slides advance. Perfect. And I am part of the Sustainable Travel Services team with GoTriangle, and I've been part of the planning committee for today's webinar, which is really exciting. So I wanted to give a quick welcome and introduction today before bringing on today's moderator and speaker. Thank you to everyone who can join us today, and we would like to give a special thank you to our regional chambers and business membership organizations that helped spread the word amongst their membership. Your assistance has helped to make this group remarkably diverse and a true representation of the business community. And as I mentioned earlier, I see a lot of new names here today, so that's fantastic to see. A quick bit of housekeeping. I know probably many of us are tired of Zoom. You've probably done a number of Zoom meetings over the course of the last year and a half or so, but as a quick reminder, the Zoom session today, it is being recorded. I do have some instructions displayed on screen. You can change your view around a little bit, so feel free to do so. This will be an open forum to have a conversation a little bit later in the webinar. So as you have questions, feel free to go ahead and post those questions into chat, and we will tackle those in the later half of this webinar. We'll have the opportunity to raise your hand, and you can turn on your camera. So if you'd rather ask the question in person instead of having to type it out, we love that. So we will be glad to unmute you and make sure that your camera is on. But otherwise, feel free to use chat for any questions or comments that you might have throughout today's webinar. And so I'm excited about today's topic. It's been something in the planning for quite a while, the topic of employment law and COVID. We're really fortunate to have Charetta Harrington as our guest speaker for today. More on that to come, of course, but if you're new here, the Mission Impossible series, it is a quick 60-minute discussion with experts on topics you want to know more about. We've had a wonderful discussion on cybersecurity, ergonomics, returning to the work site, mental health, triangle trails, and most recently, the hybrid workplace policy development, which has led into this session today. So I'm really glad that we're going to be adding employment law and COVID to that list. Be sure to visit gotriangle.org/MI to learn more about the Mission Impossible series. I'll post that link here in just a little bit in chat to make sure you can just have a clickable link. And then for today, GoTriangle, we are the host of today's session with Charetta Harrington. This information is up to date as of the time of this recording, to the best of our knowledge, as the date of this live session and recording on September 9th, 2021. As COVID guidelines and variants change, so too may the evolution of employment law, including EEO guidance and regulations. We suggest contacting the EEO office and HR staff at your company for further guidance, for guidelines and policies specific to your organization. This session is meant to be an overview and starting point for organizations. It is not an all-inclusive of EEO or HR law, or to serve as a directive of planning for your organization. If your organization does not have internal EEO or HR staff, there are professional membership organizations and contractors that you may consider contacting to seek guidance for future planning or clarification of employment law. And so now I get to welcome today's moderator. So Patricia Crane, she is the commuter systems specialist at GoTriangle. She fundraises for and manages the GoPerk Smart Commute Incentives program and oversees the Youth GoPass program. Patricia has an extensive background in nonprofit fundraising and membership and a lifelong commitment to environmental responsibility. She also has a passion for writing and editing, and she's been an important member of this planning committee sessions. With that, I'm going to go ahead and hand it on over to you, Tricia.
Thank you, Paul. As mentioned, GoTriangle is hosting today's Mission Impossible session, but I wanted to make sure that you knew more about the services that we offer. GoTriangle's employer services offers transportation expertise and complementary assistance to businesses, residential communities, and commercial properties to give them a competitive edge and to help improve transportation amenities and commuter benefits. So we like to provide options for people. These services and programs have significant impacts on commuting patterns, traffic congestion, personal health, and air quality in the Triangle. Our grant-funded services, programs, and materials are provided through a partnership of municipalities and public transportation agencies. The services and outcomes are referred to as Transportation Demand Management, or TDM. If you'd like to learn more, you can go to gotriangle.org/employer services. We've got a great deal of information there. So with that said, I'd like to welcome Charetta Harrington. She is a retired supervisory administrative judge at the Cleveland Field Office of the Equal Employment Opportunity Commission. Currently, Ms. Harrington volunteers with the Cleveland Field Office conducting settlement conferences. And as a federal contractor, she worked for a federal agency as the acting branch chief, assisting and consulting with the reasonable accommodations team. Charetta conducts federal EEO trainings for various federal agencies and as assigned by the Office of Federal Operations, Federal Outreach and Training Division of EEOC. She also writes final agency decisions for federal agencies as a federal contractor. She's admitted to the bar in the state of Ohio and to the U.S. District Court, Northern District of Ohio, and is a certified mediator, having completed the National Judicial College's mediation course. So with that, welcome, Charetta, and take it away.
Thank you very much. Good afternoon, everyone. Thank you, Paul, Patricia, Kim, Shelley, Amanda, so much for giving me this opportunity to present today at your webinar. Looks like you've had some very interesting webinars in the past, and I feel honored that you are adding this one to your list. I want to mention before I get started to everyone that I have a little connection to the North Carolina area. I was born and raised in Kinston and have family still living in Eastern North Carolina, Kinston, New Bern, Goldsboro, Raleigh, and in Western North Carolina. So I'm feeling, rather right at home presenting with you today. Let's talk a little bit about COVID and the implications of returning to the workplace. EEOC guidelines are available to you at eeoc.gov. Next slide, please. Now, let me say this at the outset. I am presenting today based on my interpretation of the EEOC guideline, what you should know about COVID-19 and the ADA, the Rehabilitation Act, and other EEO laws. This is not to mean that I am providing legal advice to any of you, but I can, based on my experience, answer any questions that you have at the end of the presentation. And if I don't know the answer, I can at least point you to someone who does, okay? Or provide perhaps later information to you that would respond to your questions. The EEOC, if you're familiar with the EEOC, that stands for Equal Employment Opportunity Commission. And it is an independent federal agency that enforces anti-discrimination laws. Those laws include the ones that we're going to talk today in detail. Well, not quite in as much detail as I would like, but as much as possible in 20, 25 minutes or so. And these laws are the Americans with Disabilities Act or the Rehabilitation Act. The Rehabilitation Act is the federal law that prohibits disability discrimination and protects federal employees and applicants for federal jobs. The ADA, or the Americans with Disabilities Act, is the law that protected people from disability discrimination, and it was enacted much later in 1990, I believe, than the Rehab Act, which was enacted in 1973. So those that law, ADA and the Rehab Act, is synonymous. Everything is the same with respect to how we apply the law and analyze the law, okay? The other laws that EEOC covers that we'll talk a little bit about today is Title VII of the Civil Rights Act, and that protects us against discrimination based on our race, color, sex, religion, national origin, and pregnancy. The Age Discrimination in Employment Act protects us against age discrimination. And GINA, the Genetic Information Non-Discrimination Act, protects us against employers using our genetic information or family medical history to make employment decisions. They are prohibited from doing that. There are also other restrictions under GINA with respect to using genetic information, acquiring it, purchasing it, and disclosing your family medical information, okay? There is an EEOC office in Raleigh, and I encourage you to reach out to that office for assistance with respect to EEOC's guidelines on COVID. Also remember that you can go onto our website, eeoc.gov. There is a wealth of information there, wealth of information that could help any employer, any employee or applicant to figure out, you know, what their rights are with respect to returning to the workplace. The guideline is not the first one that has been issued by EEOC that we will discuss today. I am discussing the most recent guideline, which was updated in May of 2021. And know this, EEOC issued a guideline during the H1N1 I don't know if that was called a pandemic or not. I don't think so, but it was outbreak it was called. And they have since been updating the guidelines based on the CDC guidelines and other public health authorities. The EEOC guidelines only relate to the laws that EEOC enforces, okay? So what's covered in these guidelines? First of all, medical exams. As you might know, there are certain circumstances under which employers can ask disability-related questions. And that occurs when, for example, a person applies for a job and they have not been offered the job. Well, during that application process, you're not allowed to be asked disability-related questions or inquiries. But let's say they are offering a job to an employee. Well, are medical exams allowed at that point? And these medical exams in the COVID guidelines here are discussing whether, you know, you can ask someone to take their temperature when they return to the workplace. If you can ask them to take a COVID test that the employer is providing, that kind of thing. So you want to check the guidelines if you have any doubts or questions as to what you can ask employees to do with respect to medical exams during your returning employees back to the workplace. After an employee, now let me back up. You can always ask disability-related inquiries after you have offered a person a job, as long as those inquiries are made of all of the people, applicants in that job category, et cetera. Now, they have to be, once the employee begins working, these inquiries and medical exams have to be job-related and consistent with business necessity. So you'll hear me say that frequently before we finish today. The other items that are covered in the guidelines, we'll move to confidentiality of medical information. Under the ADA and the Rehab Act, there is strict guidance on maintaining medical information of employees, whether their medical information, and that's whether they are disabled or not. The personnel record should not be commingled with the medical record of the employee. Okay, so if you're maintaining the employee's medical information, employers out there, and you're teleworking, how do you keep that information confidential? You keep it confidential at work. You have a locked cabinet in your locked office, you know, but what do you do if you're at home? Well, the guideline says, you know, don't leave it out on your kitchen table. You do have to maintain as much as humanly possible that information in a confidential manner. So keep that in mind. All right. Hiring and onboarding. There are several questions that come up with respect to the hiring and onboarding of employees during COVID and returning employees back to work. Can you delay the start date, for example? They cover that in the guidelines. Let's say you hired an applicant and they're supposed to start October 1 and they notify you that they have COVID. Can you delay their start date? And of course, the answer is yes, because the CDC has determined that employees or people should not be allowed in the workplace if they have COVID or have symptoms of COVID. That is why it's okay also to ask employees if they have the symptoms. Do you have a fever? Yada, yada. You probably have been to, like me, doctor's office, and before you could enter into the doctor's office, you're stopped, you're asked a series of questions that relate to the symptoms of COVID. Those kind of inquiries are okay under our laws. Can you withdraw a job offer? Let's say you've had an prospective employee who informs you that they have COVID or they have symptoms of COVID, and you needed that employee to start, you know, yesterday. And so can you withdraw the offer and get someone else who can come and start right away? Well, the answer is yes. Okay, that is covered under our hiring and onboarding guideline. Can you give me next slide, Paul? Thank you. And then we have reasonable accommodation, which is probably the biggest portion in the guidelines, that and vaccinations. I will go into a little bit more detail about reasonable accommodation. So I want to just throw this out there to you now. Do you know your employer's reasonable accommodation procedures? Employers, have you shared or worked out a process with your managers and supervisors for reasonable accommodation, so that when employees are calling in or emailing you with questions regarding reasonable accommodation, you will be able to respond in a consistent fashion and accurate fashion, whatever your agency or your company's policy is. Reasonable accommodation comes up under the disability laws, as well as under Title VII, religion. People may say, you know, they cannot return to the workplace as required because they have a disability, or because they have a religious belief or practice that would not allow them to come in. We'll talk about that a little more later. Harassment because of race, national origin, and other protected bases, they are covering these incidences where you see in the news of Asian Americans and Chinese Americans being mistreated or harassed based on their national origin or race. For example, a teleworking employee is sending harassing emails to a coworker that they believe is Asian. And they're, you know, people initially, when COVID was the reason for the shutdown, there were a lot of attacks, physical and verbal attacks against Chinese and Asian Americans, and very violent in some cases. As employers, it is the employer's duty to provide a workplace free of harassment, regardless of what the protected basis is: race, sex, national origin, disability, age, just religion. So that doesn't change because we're talking about COVID. Employees have the same protection under the law to work in an environment free of harassment. Okay, returning to work, that is under G of these guidelines, tab G. The guidelines are set out in Q&A fashion. So they're easy to read and pinpoint, you know, if you have a particular problem, they are set out by category, as you see here. If your concern is about reasonable accommodation, you'll see all the questions under reasonable accommodation. And they also provide you with the resources regarding those particular topics, reasonable accommodation, whatever their response is. Let's say, well, let's get now to vaccinations is the final category of topics covered in these guidelines. And this category is very detailed. EEOC says that the federal EEO laws do not prevent anyone, any employer, from requiring all employees to physically return to the workplace and be vaccinated, okay? And be vaccinated for COVID, okay? They can't require you to be vaccinated for shingles or, you know, the flu, but be vaccinated for COVID under these guidelines. All of this, however, this requirement to be vaccinated is subject to federal EEO laws. You can't treat people differently because they refuse to come back to work because they refuse to get the vaccine. Next slide, please. Let's delve into this a little more. What if an employee requests to not return to the workplace because of concern for a family member who has a serious or chronic illness, immunocompromised? Should that request be granted or denied? What do you think? What do you think? Next slide. The Rehabilitation Act and the ADA requires that agencies provide reasonable accommodation for employees or applicants for federal jobs under the Rehab Act who are, one, an individual with a disability within the meaning of the acts. Two, they are a qualified individual with a disability, meaning that they can perform the essential functions of the job with or without reasonable accommodation. If they meet that threshold, the employer is required to provide reasonable accommodation. Well, in the scenario or the question asked, it was, what if an employee requests not to return to the workplace? They're seeking that as a reasonable accommodation because of a family member who has a serious illness, and they don't want to, put them at risk by coming into work and they contract COVID and then bring it home. Employers, that was my watch, I'm sorry. Employers are not required to provide reasonable accommodation to an employee who is not disabled. So in that situation, the employee is associated with someone who has a disability. Let's say that, okay? So the protection, though, is limited under that situation for the employee to being not discriminated against and treated differently, or they should not be harassed because of their association with someone with a disability. But the company agency is not required to provide accommodation, reasonable accommodation, because the employee doesn't have a disability, okay? If the employee has a disability, then the agency must provide a reasonable accommodation unless it would create an undue hardship, okay? What if, for example, the disability is a hearing loss, okay? Nothing to do with COVID, all right? Does it matter? Does this matter? It could. The employee may ask to stay at home, but the accommodation is supposed to make it so that the employee can perform the essential functions of their job effectively, okay? And so you have to go through that interactive process for reasonable accommodation to determine the needs of the employee for the reasonable accommodation that they're requesting. Next slide. Prior to the pandemic, the employee was receiving reasonable accommodation and now needs an additional reasonable accommodation. So what should the supervisor do? Supervisor should, next slide, consider reasonable accommodation options. They should, the person may have a different disability, or it could be the same disability, but there's some change. It could have worsened, and the condition could have worsened, and they need a different kind of accommodation. So the supervisor should go through the reasonable accommodation process. Don't just, shout out, no, I'm not doing that. No, go through the process. Okay. All right. And the agency or the employer is required to provide the accommodation unless it would create an undue hardship. Okay, next slide, please. How much time? Ooh, 2:30. Okay, so can an employer require a COVID vaccination for all employees returning to the workplace? And of course, the answer to that is, as I mentioned earlier, the EEO federal laws do not prevent employers from requiring all employees to return to the workplace, who return to the workplace, to be vaccinated. But what about that employee who is unable to get the vaccine because of a disability? Well, There, next slide, you will discuss with that employee their disability and go through the reasonable accommodation process, okay? That reasonable accommodation process is so important. You must go through that interactive discussion with the employee and find out what the need is and provide the accommodation unless it would create an undue hardship. There's a lot to this particular question because the person, the employer can also go through this analysis to determine whether having that employee return to the workplace without the vaccine is a direct threat to the safety of the employee and others in the workplace. Well, CDC has already determined that it is a direct threat to have employees in the workplace who have COVID or have the symptoms. So agencies and employers, they can rely on CDC recommendations when deciding whether or not they can provide an effective, reasonable accommodation for an employee, and if under these circumstances, and if they can't, it would pose an undue hardship, okay? All right, next slide. What if that person is saying, I can't get vaccinated because of my religion? You go through the same process, except for reasonable accommodation under religion is a lot less strict a standard than under disability reasonable accommodation to prove undue hardship. But you use the same best practices that you would use for reasonable accommodation in a disability case as you would in the situation where the person couldn't come in based on religion. What are some examples of reasonable accommodation for and disability? Unvaccinated employees can wear a face mask. They should social distance from everybody, co-workers as well as customers that come into the business or agency, contractors that come in. They can be offered a modified shift. Sometimes you can have them come in when there are less employees in the workplace and they are less than at risk to contract COVID. Periodic COVID tests can be given. I've seen companies test people weekly, and that was before we had the vaccines, okay? Always there's that opportunity to telework, or they can accept reassignment. Reassignment is the accommodation of last resort. Remember that, okay? All right, so next slide. Again, for religious beliefs or practices that prohibit a person from getting a vaccine, employers, if they ask for an exemption to not be required to be vaccinated, then you have to go through, is a reasonable accommodation needed, analysis, and go from there, okay? What if the person is pregnant? Well, employers can provide flexibility with respect to pregnancy. Being pregnant alone is not a disability. So reasonable accommodation would not apply here. It applies if the pregnancy results in pregnancy related medical conditions that rise to the level of a disability, okay? So for an employee who can't be vaccinated because they're pregnant, then you may have to make adjustments like to keep that person working. Now, you would treat them that pregnant person just like you would treat a non-pregnant person who couldn't come in because they had a temporary impairment, okay, like a broken leg or broken ankle. If you make adjustments for those individuals who have these temporary impairments, then you have to make the adjustments for the pregnant employee. Modifications could include some of the same accommodations that you provide for disability and religious accommodations, but just make sure that you treat the pregnant employee the same as you would the non-pregnant employee. You let them use leave, they can telework, you can modify the job duties if needed, and you can change the work schedule. Those are examples. Employers cannot exclude an employee from the workplace, okay, just out of the goodness of their hearts, because they feel that it would put them at risk of contracting COVID if they were in the workplace. That's their reason. It's benevolent, it's wonderful, but employers cannot exclude that pregnant employee involuntarily, okay? That would violate Title VII of the Civil Rights Act for them to do so. That goodwill violating Title VII, okay? All right. I think that covers all of the guidelines that I wanted to point out to you in this short amount of time. I'm encouraging you strongly, if you are working on your reasonable accommodation procedures, take a look at these guidelines, and they provide for you at EEOC.gov all of the resources within the guidelines. They provide the resources that you would need to respond to just a variety of issues that will come up and have come up already, okay? Thank you very much. I'm turning it back to you, Paul.
All righty, I think this is I'm going to go ahead and get things going here. Sorry about that. Thank you so much, Charetta. That was a lot of information. I know that we've got a lot of good questions coming in from the chat and from the RSVP form. So thank you everybody who participated there. As we move into the question and answer portion of today's webinar, I'd like to highlight that this session is not a political conversation, and the host and presenter are not here to address policy decisions. So we respectfully ask that participants refrain from questions that are specific to politics. Our intent here today is to engage in a conversation that's informative and useful for everyone regarding employment law and COVID-19. So with that said, let's go ahead and get to some of the questions that we had from our chat. The first was, one of our partners is requiring all employees to be fully vaccinated for COVID by X date. Can that employer ask for a physician's note for a valid medical exemption? Remote work is not an option. And if the employee can't provide a doctor's note, in other words, if it's simply their personal preference not to be vaccinated, can that employee be terminated?
Okay. Well, yes, the employer can bar that employee from the workplace. And at some point, yeah, I'm assuming it would lead to an adverse action. Okay.
Okay, thank you. We had, along those lines, we had another question from the chat. What type of document is needed to prove a disability? And along with that, what documentation is needed for religious exemptions for vaccines?
Okay. For disability, the documentation that is provided under the reasonable accommodation process is usually very specifically requested. For example, if it is not an obvious medical condition, let's say PTSD, anxiety, some of that nature, as opposed to, blindness, that's obvious. Well, then for that employee, the employer should provide the employee and that employee's medical professional with the essential functions of their job. And then the doctor or medical professional will review those essential functions of the job, those job duties that, are not required by the employer to delete from the employee's performance standards. Those are the job duties that are essential. Now, and not those job duties that they perform, say, once a year. This is something that they must do to carry out their job, and they're needed to do. And so the doctor compares those job duties to the impairment and explains what the accommodation should be. Okay. Now, with respect, and then the employer and the employee, they review the doctor's statement, and then they discuss whether or not it would pose an undue hardship for the employer to provide that accommodation. And they come up during this interactive process, hopefully, with what will work to make that employee be able to perform effectively the essential functions of their job. With respect to religion, that's a little different. If the employer, first of all, we see all kinds of religious practices and beliefs that are new to us. We don't know them all. We don't practice them all. And we may or may not believe in that particular belief or practice. But if the employee has a sincerely held religious belief or practice, and the employer is not disputing that, then the employee should be reasonably accommodated. But if there is some objective evidence that the employer has that makes them want to get more information about the particular belief or practice, then they can ask the employee to provide a statement from, the professional or their pastor or whoever is responsible for the worship or practice. Now, what if, though, the person doesn't have anybody like that? Then that person can provide in response what their belief and what their practice is, how they're doing that, okay? And employers, you should seek legal advice with respect to that kind of situation, okay? That's something that, could turn and end up in a different fashion if it's not analyzed properly. Okay.
Thank you. Sort of along those same lines. So I think we may have answered this just now, but what would you have to demonstrate to qualify for a religious exemption? So essentially, it's a statement from your faith leader, or barring that, some sort of explanation on your own.
Yeah, and again, the employer may want to provide the essential functions of the job so that, or whatever the requirement is. But in this case, the requirement was to be vaccinated, and the employer will have a statement as to why they are requiring this. Everybody knows, but they should have that. And the person who responds can say how this requirement affects their belief or practice in a negative fashion. Okay.
Thank you. So if we have another question, if an employer has a vaccine mandate, How should they implement COVID vaccine tracking? In other words, keeping track of who is vaccinated, and what should be considered compliant. What practices? What are the best practices for that without running into an EEO violation or issue?
The biggest best practice is maintaining confidentiality with respect to that information. It's still somebody's medical information, and whether they're disabled or not, we are protected from the inappropriate disclosure of that medical information. So that tracking can be done by, say, your medical unit or one particular person under lock and key. The guidelines do provide a response to that. And I believe the best practice was maintaining confidentiality.
Thank you. Along the lines of reasonable accommodations, is working off shift, so during hours when no other staff is in the building, is that a reasonable accommodation for an employee who's not vaccinated due to disability or religious beliefs?
Yes, that has been mentioned. Modifying the work schedule so that that employee comes in when there are fewer people at work. Also, they talked about modifying the shifts. Let's say the shift where the distribution line, for lack of a better word, I can see the conveyor belt going. I can see I Love Lucy eating that chocolate on the conveyor belt. But the individual who is at risk and unvaccinated can be allowed to come in at a later shift where there are not as many workers on that belt. And so they're spread out. They can be socially distanced. Yeah. And there's so many other things too that with respect to accommodations that people can practice, like having modified protective gear. If they have the gear that you see doctors wearing, where they're double gowns and they have these masks on and the shield, any protective gear that can be used, gloves, social distancing, that kind of thing. Yeah.
All righty, we've got another question from the chat. If employers are implementing a vaccination program, are they required to provide paid leave in order for employees to obtain or recover from the vaccine?
Well, that's a good question. If I take a vaccine and I'm working and I get sick, because a lot of people did experience symptoms that would not allow them to come into work. Am I entitled to use my sick leave? Absolutely, yes. And a lot of employees don't understand that using your leave is a form of reasonable accommodation. It also is, there for you to use if you're ill. Yeah.
Okay, thank you. So what can employers do to protect employees who work with the public when their customers are not required to be vaccinated or masked?
Yeah, that would constitute, the barriers, those shields. They can require, maybe, now I've seen this, they require everyone who enters, customers as well as contractors, to wear masks, and the employee will wear a mask and be vaccinated, of course. And I don't know what else they could do, what else you could do. Yeah.
All righty, I think we had a question. Amanda, did you have a question that you wanted to ask?
Yeah, and actually you've already answered a lot of the questions, so thank you for being so thorough.
Good.
I think I'm still kind of curious if an employer is going to require the vaccine, what is the proof of vaccine? What is considered, you know, the proof that you would need to provide to the employer? Is it just the card that they gave
Yeah,
during
probably.
vaccination? Okay.
Yeah, I would think that it would be that card, you know, yeah.
Even though
So-
that could be, I guess, replicated and abused, does that still count as being sufficient?
Well, if there is some suspicion about it, then, you know, the employer can take whatever action they need to take. But the other thing they can ask is the person to bring in a statement from the doctor, okay? But, you know, people have been forging doctor statements too. So, you know, it does ask us to trust that people will provide, you know, that card. That card is important today. Yeah.
Thank you.
Thank you.
Thank you. We're getting a few questions that are, you know, concerning the idea of constitutional rights, concerns about, are there any concerns about, you know, constitutional rights versus, you know, religious beliefs, et cetera, when it comes to vaccination and working?
Well, since this presentation is concerning EEOC and their COVID guidelines with respect to the federal laws that EEOC enforces, I can't answer any con law, you know, questions. These guidelines provide you with the information you need so that you will not violate any anti-discrimination statute in trying to keep people safe at work and keep your business going. Because let's face it, I see signs everywhere hiring, you know, right now. I even saw one, please bring your 15-year-old in to fill in a job application, you know. So the constitutional rights, you have to get that from a different agency, but not from EEOC. That is not what we are trying to relay here in the guidelines. Yeah.
Thank you. This is an interesting question. How do we know if severe anxiety about returning to work crosses over into the territory of being a mental illness that needs an ADA accommodation? How is that determined?
Well, severe anxiety can be a disability covered under ADA. And then if it is covered under ADA, if you need an accommodation and make that request, then the employer is obligated to provide that accommodation unless it would create an undue hardship. Now, severe anxieties are under mental illness. And if, you know, you need an accommodation for that, ask for it. You know, people can work and perform the essential functions of their job, even though they have severe anxieties. They may need an accommodation. But you know what? Also, I saw something recently about people developing these anxieties as a result of the pandemic. And then returning to work, they can't do it. Well, again, that employee should make a request for reasonable accommodation. That employer, as a best practice, before the employees return to work, can notify all employees that you're required to return to work under whatever circumstances are. And if you need an accommodation, you may do this, this, and that. All reasonable accommodation requests will be considered on an individualized basis. Boom. Okay.
Thank you. I think this is a good question to wrap up with. So on the EEOC.gov site, is there a newsletter or other resources that people can sign up for to get updates in their inbox?
Yes, when you go on to EEOC.gov, a box pops up and invites you to sign up for emails that give you news alerts. It lets you know, I love it. It lets you know what's going on at EEOC with respect to issuance of the COVID guidances. If they sue and settle a case or win a case, you get that information immediately. It's wonderful. Yeah. Okay.
Thank you.
Thank you. Thank you all very much. And I hope you all stay safe.
We'll hand it back over to Paul to wrap things up.
Yeah, great. Thank you. So I am real quickly going to post this in chat just so you have a link that you can click on. We do ask that all participants complete this survey. It really does help us get an idea of if this session hit the mark, and then it also allows you the opportunity to tell us about anything that you might be interested in. A lot of our Mission Impossible series have taken shape because of feedback from our audience. So the survey is a fantastic way to share your thoughts on that. This survey is anonymous, so feel free to ask anything and everything, and we're glad to expand upon that at a future date. So thank you for, we know we usually have really good survey results, so thank you for those who can complete the survey. And then I am going to share some contact information. Charetta, you're probably going to yell at me. We do have your email address here. I got a feeling that you're probably going to direct a lot of people to the EEOC.gov if questions do come your way. So I think just that's a very natural place to get started. You had an impossible task of trying to summarize a whole lot of information in a very, very short amount of time. And I think you've done an absolutely wonderful job of that today. But I also know that there's a whole lot of information out there to process and to read through, and for employers to evaluate as they're making decisions on their end. So it sounds like the EEOC.gov is a fantastic resource, but hopefully GoTriangle, we have our contact information, my information's there, Patricia's information's there. As always, feel free to reach out to us. We are always glad to help answer any questions to the best of our ability. Let us know if you have any questions, and thank you so much for joining us today.